Welcome to the second best of the best episode of Inside Medical Malpractice. As you may know, at the end of almost every episode we recorded, I ask each of our guests to share the most important thing they'd like healthcare providers, lawyers, and the general public to know about medical malpractice. Our guests have come from across Canada and the US and included doctors, nurses, a dentist, plaintiff and defense lawyers, and a Supreme Court judge. Their answers to that question have been as unique as their perspectives, but always astute, insightful, and thought-provoking. We've put together what we thought were the best pieces of advice in two fascinating episodes, the first of which was released last month. So if you missed it, have a listen. But listen in now because I promise you'll learn something, and I hope you'll really enjoy this. First up, Winnipeg neonatologist Dr. Michael Narvey, co-author of the Canadian Pediatric Society Guideline on Neonatal Hypoglycemia and expert witness, offers his advice to doctors, nurses, lawyers, and the public on the most important thing he feels they need to know about malpractice. His message to healthcare providers came to him while he was sitting on the hot seat in the courtroom. He says, "This is not about you. It's about a lawyer doing his job and trying to give the best defense to his client." Have a listen. What is the most important thing that you'd like lawyers to know about neonatal lawsuits?
I think the most important thing is to recognize that, and we talked about a little bit about this in the webinar. The CPS statements and practice points are a consensus-based approach to care. We try to state now more and more in the statements what the level of the evidence is for something. And I think that, as I said at the outset of this podcast, we all are exposed to the same literature, yet sometimes we come up with different perspectives on it.
Yeah.
And so I think that it's not black and white. So much of what we do is not black and white, and there will be variations in how people approach problems in their own center. Some of them may be, in my estimation, a little outlandish, but most of them are going to be pretty close to the mean. And the other thing that's interesting is just how opinions can differ between neonatologists. I had a very interesting experience of working on a case which is still active, so I won't go into too much detail, except to say, serendipitously, 3 neonatologists, including myself, discovered we'd all been asked for opinions on the same case. And with permission from the lawyer who was involved and who had solicited all 3 of our opinions, we had a conversation together.
You all knew each other?
Yeah, we worked together. Yeah, we all.
You worked together.
We'd all, at various points in my career, we had worked together.
Right.
But we didn't. None of us up till that point knew that we had all been asked to give opinions on the case.
Mm-hmm.
And what was described by the senior person in the group was, he said to me, "I'm here, you're here, and the other neonatologist is here." Meaning, I think that in general, opinions are pretty consistent. I think that's one thing that I would say, is that I think opinions are pretty consistent. There is going to be fine points we may differ on, but I think that the gist of the opinion is going to be probably similar, just based on that one experience. And I would say I'd read in the same case, I'd read an opinion from a doctor who I know, who was shared with me. And I read the opinion after I had already formulated my own opinion. And we were, very, very subtly different in our wording, but pretty close.
Oh, good.
Yeah.
Because sometimes those opinions are miles apart.
Yes, I've seen that.
Yes.
You know where I've seen that more so, though? I've noticed that on the obstetrical side.
Mm.
It seems to me, the whole process of interpreting these, tracings.
Yeah.
I'll see one obstetrician say, didn't think it was that bad. The variability seemed reasonable. Another one say no variability or absent.
Yeah.
One's worried about variable D cells. The other one thinks the tracing is not very reliable, So I think you get a little bit more variability there.
Right.
But I think on the neonatal side, I've not seen, and radiology, I've also noticed, you sometimes see very different opinions about the same images. Depending on which part of the country you're asking.
Yes. Yes, that can be very true. All right. Well, that was a great answer for lawyers. So answer that same question for healthcare providers. And you can break this down separate for doctors and nurses if you choose. But what is in your view, what's the most important thing based on your experience as a clinician and now as someone who's provided expert opinion, most important thing that healthcare providers need to know about neonatal lawsuits?
I think the most important thing is do not take it as a personal attack. It's very easy to take it as a personal attack, but I remember being in court as an expert witness for a case, the Crown versus Giesbrecht, which has been resolved here in Manitoba. And I remember being in there and being cross-examined as an expert witness, as a neonatologist. And there was a moment like that, because I could see I don't easily get riled up, but I could feel as I'm being cross-examined, it was about an hour and 45 on the stand. And by about the 1 hour 20 point of going over the same thing over and over and over again and attacking different ways of looking at it, I was getting emotional.
Yeah.
And I was starting I noticed I gave one answer, and not intentionally, but I sensed that it may have come across as showing I was getting a bit irritated.
Right.
And I took a moment, and this is the message I would give to all the healthcare providers. I took a moment and I said to myself, this is not about you. This is about a lawyer doing his job and trying to give the best defense for his client.
Right.
He doesn't know you. He actually doesn't care about you, like as far as worrying about what you're having
as a person,
tonight, or whether you're going to have a nice evening after this. And that's not to say they're wishing ill of me, but this is all about trying to find some sort of weakness to exploit, to create doubt.
Sure.
And to be able to just simply say, well, there could be some doubt about how solid my answer is. And so once I said that to myself, I just came right down.
Good.
And I thought, just answer the questions.
Yeah.
It's not about you. Yeah. And that's the same thing I would say to the doctors and the nurses out there is, if this is, don't get me wrong. If I open a letter someday, as I told Joe before, I get a letter from any lawyer, any, as soon as I see law office and it's mailed to me, my blood pressure goes up and I think, is this the day? Right?
Yeah.
Thankfully,
it's not your favorite. It's not your favorite day. No.
However, what I would say is to all of us out there, just remember, just like we have a job to provide care for the patients that we care for, lawyers have jobs to provide a defense or to prosecute for perceived wrongdoing.
Yeah.
And once you realize that this is a job no different than the job you're providing, they care about their clients, we care about our patients.
Yeah.
And this is a process. And ultimately, I would like to think that the law will do what's right. So the process will do what's right. So if you are named and there is no case, there will be no case.
Right.
But if there is something clearly that was some wrongdoing, then what I would say to them is accept it and use it. And, write in your brain, if this ever happens again, I will not do this.
Right. Exactly.
So learn from it.
Well, that's really, really good advice. And I hope it's very calming to any doctor or nurse in the country who has been or currently being named in a lawsuit. But I, I hope it's also a really good lesson too for healthcare experts who do expert witness work, because certainly the cross-examination on the stand, we didn't get into that in any at any great length today, but that's that single experience is what keeps doctors and nurses from doing expert witness work sometimes, because they're so frightened of that, what can be a very highly adversarial experience. So I think you just gave some good advice on many, many different levels there. So thank you. And another question along that same line. In your view, what is the most important thing that the general public, that the mothers and the fathers and the grandparents of the babies who are being born need to know about neonatal lawsuits?
I think what they need to know is that, a few things really. I think number one, I really do believe people go into healthcare because they want to help people. I don't believe, you hear the occasional sensational story about somebody who is not mentally well, who is in healthcare and has been intentionally harming people. But, that's the 1 in 10 million, right? The people who go into healthcare go in because they have a genuine desire to help. And so sometimes, despite everybody's best efforts, things can go wrong. And much like I had to sit in a witness stand and I had to come to the realization that this was not about me. This was not about somebody trying to hurt me. I think that it's okay to grieve. It's okay to be angry and go through all the stages of grief, and getting over that. If you need to pursue a lawsuit, that's your prerogative. And sometimes, so I guess my message is sometimes despite all of our best intentions, things go wrong. And if they go wrong and you feel you need to pursue a lawsuit, then you do what you have to do. And in part, if there has been something missed, if there's been something, that was not done properly, much like when we say, why should parents go into consent for research in the NICU? I just told a family just yesterday, and my answer, I said, you know what? This research study may not help your baby at all. However, the findings of this research study may inform practice and be better for others. And so I liken that same approach to lawsuits. You know what? The lawsuit isn't going to do anything to fix what's wrong with your baby. The damage that happened is done. And we can't, as much as we'd like to go back and erase it, we can't. But aside from a monetary acknowledgement of the injury that's occurred, the lawsuit may help inform practice and prevent it from happening again elsewhere.
Yeah.
So I think that is what I always tell families. And, that it's very difficult, as I said earlier, not to take it personally. But, I'd like to think that if my time comes and I am named at some point, I hope I never am, but if I am, that I will have the courage to be able to say to myself, this isn't about you.
Yeah.
This is, if an error happened, this is about process, and this is about ensuring that it doesn't happen again.
Former Supreme Court Chief Justice Beverly McLaughlin was a guest on the show in the fall of 2020. Her perspective of the law was rightly broad-ranging and refreshingly positive. Her words of wisdom to the healthcare profession included, "The legal system may seem a thing of mystery to many medical practitioners that find themselves involved in legal cases, and frustrating for how slow the process is. But they should remember that this is a process that has been proved over the years to produce just results. Fairness to both parties is absolutely essential." I have never forgotten those words. In your view, what is the most valuable thing that you would like lawyers to know about our legal system? Big question.
Well, I think the lawyers know this, I think, and so to say, I'd like them to know. It may sound a bit strange, but I think they know that it's a system that exists to serve the public, and that it's more than just a way of making money or even winning a particular case. It's a profession of service. And the law, more broadly, its institutions are institutions of service. They exist not just to perpetuate themselves, they exist to serve the public.
Very well said, beautifully said. As you know, my background is in healthcare, and there's a lot of differences between healthcare and law, but that being of service is something that these two professions have in common, and I've always appreciated that, lawyers who really understand that concept. And what about for healthcare providers? What would you like them to really know and understand about our Canadian legal system?
About the legal system, that it's designed to give fair outcomes, and I know it may seem a thing of mystery to many medical practitioners or others who find themselves involved in legal concepts and legal cases, giving evidence before a judge, may be sued because they've done something allegedly wrong. And they must feel frustration at how slow the process sometimes is, and they I've heard they may complain they don't understand it or understand why things are done. But I think that they should remember that this is a process which has been proved over the years to produce just results. And fairness is fairness to both parties is absolutely essential. It lies at the heart of the justice system, and they should also understand, I think, that every society has to have ideally a justice system that the people respect, a place where people can go to get their disputes resolved. And this is a way of keeping our society peaceful. If people lose faith in the law, in the justice system, they take the law into their own hands. So if I were a doctor, I'd rather have an angry patient sue me in court, go through that fair process, than run the risk that that patient might get really upset and do something outside the law. That's the kind of measure. I think I'd like to say that to people who find themselves caught up in the justice system and say, why me? It's not working right. It's slow. It is working right in the long run, and it's essential to the peaceful resolution of disputes and our security.
That was very beautifully said, and I think I certainly know a lot of healthcare providers who think that the legal system is just a thorn in their side mostly, and don't really have the understanding of what you just described about the fairness to all parties and the rights of people to, have access to damages if they're injured, and the whole process that has to happen to make that decision. So thank you. Would your answer change if I said, what do you want the general public to know about Canadian legal system?
No, I think it would be the same thing, but I would like the general public to feel, and I'm not sure they do as much as I would like, that the system is there for them. That's why I'm so keen on access to justice. I want every woman and man, even a child, to have the sense that the system belongs to them and that it's there to serve them, and that they can get justice at an affordable and within a reasonable time period. And we're working on that. That's a work in progress.
Calgary OBGYN Dr. Colin Birch, who has been a doctor, a patient, a defendant in a lawsuit, and an expert witness, shared his thoughts on what he thinks physicians need to know about malpractice. These words stuck with me. He said, "The first thing is, lawsuits are a part of our lives. In some ways, once you've gone through the rigors of a lawsuit, you could try to use it positively to improve the way you view things, the way you practice, and the way you involve yourself in patient safety." He also offers some great advice for nurses, lawyers, and patients that you don't want to miss. In your view, what is the most important thing that you would like fellow physicians to know about lawsuits in the obstetrics gynecology clinical area?
The first thing is, as I've said already, they are part of our lives, and anticipate that they're going to be part of our lives. Secondly is, we know that, and this is a bit motherhood and apple pie, is that nothing you do has been volitional. So regardless of how terrible you feel, and believe you me, physicians may not appear that way, but we feel terrible when it happens, is that you're not at fault. That, you know, first of all, you're not alone. You're not at fault. And that in some ways, once you've actually gone through the rigors of the lawsuit, which you know, have actually killed some people's careers, you know, you can use it, try and use it positively. If you can ever find something positive out of it, to improve the way you view things and the way you practice and the way you involve yourself in patient safety. So it's horrible as it might seem, you got to find something positive out of it, because otherwise the 3, 4, 5 years that these lawsuits take, and sometimes longer, really will keep you up at night and basically maybe negatively affect the way you practice.
That's the truth for anybody who's been through this. So good advice. I'm going to ask that you break that down into, for nurses as well. What would you like nurses who you work with all day, every day, to, what's the most important thing you'd like them to know about OBGYN lawsuits? Because nurses and GPs and obstetricians are very often all pulled into the same lawsuit.
Yeah. That for nurses as well, they are part of the, I mean, being part of a lawsuit basically is recognition of how important the nurses are in the team who look after patients. You know, I don't know whether it's viewed that same way by the law, but they actually are an important part of this. Now, that's great 99% of the time, but you have to remember that from the nurse's perspective, is you're part of a team. You're not alone in this, even though it might feel very lonely when it happens. You're actually part of a team, and each one of you were contributing to that patient's well-being, and you did the very best to make sure that this outcome didn't occur. But I think the message is it recognizes that you're part of the team when things are good, but also, unfortunately, when things are bad as well.
That's probably the team you don't want to be on in that moment anyway. Like no gracias to that, right?
Yeah, and you know, and the other thing from a nurse's perspective is, when you get this, remember that there's usually 10 times as many nurses named as there are physicians, because invariably, if it's an obstetrical lawsuit, it's gone through that many different nurses as well. So your part in this, if it's a part, is usually relatively small, you know, because oftentimes you've been named as one of 20 nurses who may have just been in the room to relieve for 30 seconds or something.
Yeah, good advice. So take a deep breath and look at the chart and figure out what went on.
Yeah.
What would you like the lawyers to know about OBGYN lawsuits?
I'd like lawyers to know that really, however, sometimes it may appear that what we did was, in hindsight, was so abjectly wrong in their opinion, that in fact, we're not there, we're well trained. We're not there to harm people. We are there to do our best in a situation, and I'm going to say it's a difficult situation. I think it is a difficult situation. That I think it's that sometimes they should just take a step back and realize that when a physician and nurse gets sued, it can be life-shattering for some of them. Two, as I've said before, that they have got days, months to look at something that may have taken, especially in obstetrics, and I can talk about the surgical side as well, but just obstetrics, we may have had 2 minutes to think about. And just occasionally, I know it's not perhaps what should be said, have some compassion in that situation, because you're still going to get to the end result. You're still going to have exactly the same factual outcome. You don't have to make it into this incredibly combative situation where I've seen in court, I've seen physicians and nurses have been driven into the ground by cross-examination when your point has been made. You do not need to belabor the point. You've already made the point. Hammering that person over and over again really gains nothing. And I've seen this happen, and where they've asked a great question, they've got exactly the answer they want, but they want the cherry on the top, and there's no point. Literally, there's no point. You've made the point. You've made a great case. Why continue on down that line? Because I think sometimes, to me, and I'm not the judge, and obviously a judge is a third-party person who is looking at, I would think, because I've sort of sat there sometimes and looked at the judge, and they've looked sort of quizzically like what they're talking about. They want facts in very short order given to them so they can assimilate those facts and come up with a judgment. So I'm not being critical of the law, not at all. It's just an observation I've made. But I think the lawyers just need to know that this is, not only has this been a life-changing situation for the patient and potentially the baby, but it is also life-changing for those that are sued, because they may only happen to them once or twice. I mean, that's just the way that obstetrics is. I think that's basically what I need. And don't ask, the other thing is, don't, in your instructions, make it sound like you're asking an expert witness to be an advocate. They're not. They're just there to give you the facts. Now, their summation of the facts may not be what you want, but I think that's as positive a response as having something where it's advocacy that maybe would not hold up when someone has to be cross-examined.
That's good advice. I did a presentation on this a few years ago about that word advocacy and what a different meaning it has in the legal world than it does in the medical world.
Yes.
Very different, very different. So last question for you. Answer that same question for the general public. What would you like women in labor and their families, or women undergoing gynecological surgery, to know about lawsuits in that clinical area?
I think patients sort of need to know, but first of all, they need to know the negative effect that it affects on everybody in the lawsuit. I mean, however much they can't see beyond themselves, which is totally understandable, do not get me wrong there. But they also need to know that it's an interpretation of fact which may be interpretation of fact by different people who weren't actually there at the time. So they're only working on the basis of what they can see, what they can read, and what information they have available to them. In gynecological lawsuits, it's a bit different. I mean, if you have basically gynecological, like any surgical lawsuit, lawsuits are usually because the patient has not had a satisfactory outcome that they would like, and or they've had some inadvertent injury occur whilst getting to a satisfactory outcome or an unsatisfactory outcome, whichever you look at it. And I always think that patients should know that yes, this is they're right to do this. There's right to call us into absolutely. I'm not questioning that in the slightest. What I do question sometimes is the use of lawsuits in some way to, especially even from a surgical perspective, is some way to apportion blame or apportion, my life has been badly affected, therefore, and you see this sometimes, your life therefore should be badly affected. And the message should be, again, is that we don't go to work to do harm, but harm or complication is an inherent part of medical practice, and risk is part of medical practice. That's just inherently part of it. And I don't think people quite understand that quite so much. They think that because we have such great technology now, and we have so many different ways of doing things and looking at things and so many different imagery things, that, everything's going to be perfect. No, that's not medicine. And I think the patients need to understand that.
Experienced plaintiff's lawyer Virginia May from Calgary, Alberta, also offers some words of wisdom on medical malpractice. Here's what she had to say to physicians. There's no privilege in being a doctor that allows you to do something and get away with it. But no doctor ever wants to do anything wrong. There's nothing intentional. It's negligence. Negligence isn't intent. It's allowing yourself to be careless at a certain point in the relationship. And for nurses, she said, if you're a nurse, you are automatically part of the legal system if things go wrong. And for all of us, everybody hates the law. Based on your experience in medical malpractice law and your years of being a lawyer, what's the most valuable thing that you could offer a doctor that could learn from your experience in medical malpractice?
I think a doctor should never, because they have medical experience, feel superior to their client. Mm. And to say they shouldn't feel, I can't control how people feel, but in such a way that it impacts either the way they care for a patient or the way they respond when they're sued, when they've done something wrong. Because there's no privilege in being a doctor that allows you to do something wrong and get away with it, if I can say that word. Not that no doctor ever wants to have done anything wrong. I've never found, there's no what I'd call intentional. It's negligence. Negligence isn't intent. Right. Negligence is allowing yourself to be careless at a certain point in a relationship. And it's not a jail matter, but it is a matter where somebody else, if you are negligent, is harmed. And I think many of the calls I got would never have occurred if doctors had behaved differently. And yet, they can't be blamed because they're told to say nothing and to act as if nothing has happened by their own insurers. Right. And I think that leads to many more cases. I've just got one case on that story. I had a woman, had a baby, older obstetrician, things went sideways. Child luckily recovered very well. The mother was freaked out completely and would not drive near where the surgery was or where she knew the doctor lived. Like, things would make her ill going near him. And we're having the examinations for discovery. And this doctor came in, and he came in with his lawyer. And I'm sitting there with my client who's about to throw up because she's avoided everything to do with him. Sure. And he came up to me and said, I have to speak to you. He said, they won't tell me how the child is. Nobody has told me how that baby boy is doing. And he was sick with worry. And he, just as my client had been so sick, was also absolutely distressed as anything because his lawyer had chosen to say nothing. And I said, the child has done very well. He's got very little. Now, okay, so I'm lessening the damages my client can get by saying that, but they didn't need them. You know?
So the humanness is there.
Such a relief. And then he told everything. He ignored his lawyer, who was furious with him, and he said, this is what happened. I have not delivered another baby since then. I am not going to deliver anymore. Yes. And she turned out, when she came for this discovery with me, my client, to be pregnant again. And he asked if he could see the new baby.
Oh, boy.
Well, it ended up that he dropped some vast teddy bear off at the hospital for her, for the new baby. And actually, a kind of friendship developed.
Oh, boy. Isn't that something?
But he's gone for 2 years because these things are so panic-stricken that this was a very seriously injured child, which it was not.
Well, thank you for bringing light on that humanness, because I personally have never met a doctor or a nurse who doesn't have a memory and a worry like that in their background of that day and that case and that outcome. And you don't always know the ending of the story. You don't.
No.
You lose touch, and it's acute care and it's busy and life goes on, and you just don't find out. So I'd like you to answer that same question. In your view, tell me what the most valuable thing that nurses could learn from your experience in medical malpractice.
Nurses can learn that there is nothing to fear if they are sued or if the hospital is sued.
Oh, boy.
In most instances, a nurse, I have found, I think in all the cases I did, maybe 3 occasions where a nurse may have been partially responsible for something. One, a lady had gone out for a smoke as the monitoring on a baby dropped. Now, that how would you know that was going to happen? But maybe you weren't meant to go for a smoke break. And another time, no, that's actually the only time I think that I ever found a nurse. So they're there to interpret the record and to help give a viewpoint, from my point of view, to help give a viewpoint on what actually happened, to read the scribble and the writing and why things were written down, because 90% of a record isn't written by the nurses. And if you are a nurse, you are automatically part of the legal system when things go wrong. You have no choice.
That
if
is
you were there
great advice. And I bet you just put a lot of nurses' minds and hearts at ease, because I've also never met a doctor or a nurse who doesn't see the day that statement of claim or notice is served as one of the worst days of their life. It's terrifying.
Well,
it's terrifying.
It is. Everybody hates the law. I had clients who said to me, when I got a letter, and of course there weren't emails in those days, I was actually sending letters with a stamp on.
What?
Like my stomach would sink. And it's because your mind has to go to the negative, you know?
Sure, of course. So answer that same question for the general public. Here it is. What's the most valuable thing that members of the general public could learn from your experience in medical malpractice?
That if you think there has been medical malpractice, you should, and you are familiar with the facts, you should talk to a lawyer. You may be rejected many times because there isn't a connection between the damage the person is left with and the actual negligent act, or there might not be a negligent act, but find out if there is a lawyer you can talk to and gain some information, or an expert. I need an expert to guide me. I never start a case without an expert.
Right.
But never be afraid, if you think some serious damage has occurred, to find out from a lawyer who will guide you first to talk to someone about whether or not you can. Doctors are suable. And no doctor, even if it's the guy who delivered you, is if he's done harm further down, or possibly you should try. You should check it out. Most lawyers who do medical malpractice will vet cases very quickly that shouldn't be brought.
Now, here are some fabulous comments from Dr. Danielle Ofrey, internist at Bellevue Hospital in New York and author of the amazing book, When We Do Harm. Dr. Ofrey offers particularly great advice for patients on how to avoid an adverse event, which includes: you should feel empowered to ask and know why things are happening, and don't take no for an answer. You are, in some way, the captain of the ship, so don't be afraid to say that and get a second opinion. Don't be afraid to be the squeaky wheel. You often have to. That's some really great advice right there. Do you have a little gem of advice or one valuable thing that you'd like to tell each one of those audiences? What, from your research and from your book, would you like lawyers to know?
Well, I think we touched on this a little bit, but I think I'd like lawyers to know what is the sort of grander scheme of where things are. I mean, the lawyers tend to be um, parsing down to one particular, moment, and that is just one strand of hay in a haystack. And in medicine, healthcare, we don't live with a single strand. We live in that big, messy haystack because that is patient care. Every patient's different. Things are confusing. Things are unclear. And a whole, 5 years of litigation can revolve around that single strand of hay. But that's not the experience of taking care of patients. And I think understanding that we're living in this big, confusing, unruly haystack, that is how healthcare is. So that is my sort of advice for lawyers trying to understand that perspective.
What about doctors and nurses? Or separate those two if you want to.
I could actually put them together because I think here, looking at the clinicians, I think to understand that, we clearly need the legal profession and we need lawyers and we need lawsuits. There are certain cases, particularly the class action lawsuits, that have done incredible good for patients. And I think we reflexively, lawyers, oh my gosh, let's get at our lawyer jokes and, we're allergic to them. But to respect that if we didn't have lawyers doing these class action lawsuits, we would be very further back on patient safety. And I think, as Peter Mullinex makes the analogy, in the auto industry, right, cars didn't get safer just because manufacturers said that's a great thing to do. It's because they got sued and particularly class action lawsuits. And so we do want that. We do want people looking carefully under the hood, so to speak, of healthcare. And for individual lawsuits, we do want that because there are bad apples out there. You see people who do really improper things, and we should want those people to be taken to task by the legal system. And I think because it's better for the rest of us. I think it's a small number. I honestly do. But it's important because they shouldn't be practicing medicine or practicing nursing if they are, doing things that are negligent or not putting patient care at the head of the table as it should be. So be patient with lawyers. We do need them for many things and understand their perspective is different. And listen, there may be a time where you need that lawyer and you will want them. So treat them with respect also.
Good advice right there. And what about for patients? What's the most valuable thing that you could share with them from your book?
So in terms of staying safe in medicine and healthcare, it's very hard. And partly because medicine is so chaotic and disjointed in many ways, it leaves you, the patient or the family member, to be the advocate. And that can be difficult, especially if you're sick. So of course, that sort of time-worn advice of having someone with you, if you can, to be your advocate. If you're in the hospital, someone keep a notebook, writing down what's going on, why you're getting these different medicines and tests. And to know that you own your information. Everything that's going on is yours, and that you should feel empowered to ask and to know why things are happening, and don't take no for an answer. And I think we often expect patients to be these sort of passive, just do what we say, but you are in some ways the captain of the ship, and don't be afraid to say that, and to get a second opinion. And there's always a patient advocate somewhere on staff or a patient ombudsman. And if you're not being able to sort of get your voice heard or get your questions answered, that's the person to call. You don't have to take it laying down, so to speak. You own the information. So the results of the test, they're yours. And if anyone says, you can't get them, that's actually not true. And don't be afraid to be the squeaky wheel. You often have to. Recognize that, again, most nurses and doctors are trying very hard and have more work than they can possibly do. So acknowledging that, I see you're working really hard. I'm so appreciative of the care you're giving or of this particular thing. But I also want to know that. So a little bit of acknowledging the humanity of your caregivers because they are working hard. But then don't be afraid to ask what you need to ask.
Barb Leggett, a plaintiff's medical malpractice lawyer from London, Ontario, discussed a fascinating case involving a newborn and some frightening statistics in her episode called The Christmas Effect. When I asked her advice on medical malpractice for healthcare providers, she said the words that no doctor or nurse ever wants to hear. She said, "You're not a real healthcare provider until you've been sued." Damn it. And for lawyers, she said the big mistake that many lawyers make is that they focus on the thing that goes wrong without thinking about the causation component, which is where cases are won and lost. Listen in and see what else she has to say. What's the most important thing that healthcare providers need to know about medical malpractice?
That you're not a real healthcare provider until you've been sued, and don't sweat it.
Damn. No one's going to want to hear that.
No, just write stuff down and make sure you've communicated for sure. You really have to be clear in your communication, both written and verbal. But don't sweat it. I think, you're not a real doctor until you've been sued. I've told my friends that, and then they've told me, oh, okay, I have been sued.
Oh, okay, yeah. All right, and let's talk to the audience of lawyers. What's the most important thing you'd like lawyers to know about medical malpractice, other lawyers to know about medical malpractice?
Well, if you're not doing it, don't do it until you do it with someone, or you've got a lot of trial experience in complicated cases. For myself, I had practiced about 15 years before I went into medical negligence, and I'd done some complicated trials. So, there was still a very, very steep learning curve. You have to be prepared to spend an enormous amount of time learning medicine, and you have to be prepared to spend an enormous amount of money. Staff, experts, exhibits, that kind of thing. It's not for the faint of heart. It is not for people who think, oh, well, I'll just issue this claim and they'll negotiate with me. And the other big mistake, I think, that too many lawyers make is that they focus on did something go wrong without thinking about the causation component, which is
Right.
where a lot of cases are won and lost.
Right, right. Good advice. And what about for the general public? What's the most important thing you'd like them to know about medical malpractice?
Go to somebody who knows what they're doing. Don't go to your real estate lawyer. Don't go to your family lawyer unless you're going and asking them for a recommendation for a medical negligence lawyer. We are not all created equally. Do not come to me for a real estate deal. Do not come to me if you're getting a divorce. I'm not your person. And similarly, if you have a medical negligence case, go to a specialist, someone who is competent to deal with your case, because you could be very disappointed and it could be very expensive for you too.
And finally, lawyer Michael Waite from Calgary, Alberta shared some memorable advice from the perspective of a hospital defense lawyer. This comment to the public on dealing with healthcare providers applies to everyone. Make sure you advocate for yourself. Keeping notes and making sure you try to maintain a rapport with the healthcare providers can go a long way because it's a human system. If you have a good relationship with people, things will probably go better for you. There's also some bonus advice from Mike on how to speak up to authority in the middle of difficult situations. In your view, as a hospital defense lawyer, what's the most valuable thing that the general public need to know about preventing nursing negligence or negligence? But I'm going to say nursing negligence because you most often defend nurses. What advice do you have to offer the public?
Well, I guess I would have a comment and then some advice. The comment that I would have is similar to what you said earlier, is that no one on the health provider side goes into this intending to cause harm to anyone. Everybody is doing the best they possibly can. And I think sometimes either plaintiffs or plaintiffs' counsel or even the nurses involved feel that litigation is about battle, and it becomes emotional and it becomes really adversarial. And that's not what it's meant to be. It is the system set up to provide victims of negligence with compensation. And sometimes in my conversations with nurses who are, really taking it personally, and really sometimes they'll lash out at the plaintiffs because they're taking it so personally. And sometimes I really have to snap their head back a little bit and say, wait a minute, like these people were harmed. They had an adverse outcome. Whether it was caused by someone's negligence or not is something we have to determine. But they have every right to bring this bring this statement of claim or bring this litigation and seek compensation. And we're not here to judge that decision. What we're here to do is determine whether or not everyone met the standard of care, and if not, then make sure that people get reasonable compensation. As far as what the general public should know, I think I hesitate to talk about advocating for yourself, because I think there can be a real downside to that.
What's the downside?
I think because it can create an adversarial relationship immediately upon entering in the hospital, and if you're pushing too hard, if you're, I always say about myself, a little knowledge is a dangerous thing, right? So people have some symptoms, or they know they have a preliminary diagnosis, and they go consult Dr. Google, and then they're really pushing hard because everybody tells them that's what they have to do. It can become a barrier, and I've seen this in cases where the rapport and relationship between the patients and the health providers breaks down early on because people are being too aggressive. So I guess what I would say is you do have to advocate for yourself, in that you have to be informed. Take notes. Bring a pad of paper. Like, I've had, unfortunately, quite a bit of interactions with the healthcare system in my personal life. My brother was diagnosed with glioblastoma and passed away a year and a half later from a brain tumor. My father passed away last February. My wife has leukemia. So I've had my share of sitting in as a support person. Thankfully, I'm healthy, but as sitting in as a support person in doctors' meetings, and I'm there to take notes, right? I write down what's said, because often as the patient, you don't hear it. You're upset, you're elevated, you're scared. And so having somebody there with you, just taking some notes, and not again in an adversarial way with the doctor, but just trying to keep it straight so you can go have a conversation at the kitchen table later on when you're a little more calm and talk about, okay, well, what did the doctor say? Mm-hmm. So I think, making sure you advocate for yourself, keeping notes, and making sure you try to maintain a rapport with the health providers can go a long way, because it's a human system. Mm-hmm. And if you have a good relationship with people, things will probably go better for you.
That's a really good point. And I agree with you. There is an art to advocacy, without a doubt. And I just want to make a comment that the people in your life are lucky to have you as their advocate at this point. So
it can be a downside, when both of my boys were born and we were in the labor and delivery room, I was looking at the strip coming out of the machine, and I was asking about D cells, and people were looking at me like rolling their eyes like, oh my God. So, it can be a barrier at times, but
I'll tell you 100%, the doctors and nurses looking after your wife were petrified all day. I know that from behind the scenes. But anyway, thanks for those awesome and very insightful comments. And I think great advice. What about, what advice do you have for nurses to avoid litigation?
I think we talked about documentation earlier. It's an obvious one, making sure you're documenting the important things. I also think stepping out of the hierarchical structure of the healthcare system. The healthcare system has gone a long way to improving its hierarchical structure. I did my master's in law in 2005, 2006, and what I was focused on is patient safety and incidents of healthcare error. And one of the things that was a big part of the literature then was in aviation, how they'd made great strides in safety because they got rid of this hierarchical structure in the cockpit, where the co-pilot who was more junior would be afraid to speak up if they saw something that was going wrong. And there were crashes that occurred where they felt largely that was the reason. And I think as between doctors, that's a problem. And that's advice I would give to doctors. As a resident, there are times when you should be speaking out and you choose not to. You have to choose to. You have to choose to speak out and trust that the consequences will be what they will be, but they won't be unreasonable. And for nurses, it's the same thing, like being willing to advocate for your patient, being willing to advocate for yourself. If you feel that things aren't going the way you think they should. And there's a chain of command you can go to, a charge nurse or your manager. If you need to, you can go over the head of the physician you're working with and go to another physician or a specialist. You don't do that in every case, but when you feel like you should be doing that, then you really should be doing that. I think that's one thing that I see where, in retrospect, reviewing a case or reviewing a chart, you can kind of see things going in a certain direction. And there were opportunities for residents or other physicians or nurses or others to have raised an alarm bell, and they didn't. Mm-hmm. And so I think that's a key. Don't just go along with a practice or policy or a culture in a unit. You've got an obligation to your patient. You've got a professional obligation to look out for your patient. So sometimes that means doing something that's uncomfortable.
Yeah, that's true. I see that in a lot of cases as well. There's a moment where something could have been said or done, and it wasn't done. But what advice do you have for the nurse or the doctor or the resident in that moment? I mean, it takes a lot of courage, and that's what nurses will often tell me. I can't do that. I mean, I don't have the courage to do that. No one will listen to me if I do speak up. Any advice for finding the fortitude that it takes in that moment to say what needs to be said?
Yeah, I mean, everybody has their own strengths and weaknesses. I think what I would say is, if there's we keep talking about baby cases, that seems to be what's on my mind.
Yeah. It's always on my mind.
Yeah, you don't necessarily have to go to that obstetrician who has a reputation for being very difficult and for chewing people out and that kind of thing. You can go to your patient care manager or your charge nurse, but what you say matters. So going to them and equivocating or just kind of raising a concern but not really saying what you think needs to happen isn't sufficient. Like if you have a serious concern and you think, for example, their baby's in distress, or that the GP who's caring for the mom should consult obstetrics, or whatever the circumstances, you need to say it, and then you need to document it. And then I think you've discharged your duty as a nurse. At the end of the day, there are limits to the scope of practice. You don't have a legal obligation to set your hair on fire in the hospital, and you have a legal obligation to take reasonable steps to try to raise a question. And at the end of the day, a clinical decision will be made by someone else. But I think it's not enough to say, she wouldn't listen to me, or right, I'm afraid to speak to that person. I think there are other ways to go about going about it, and then somebody who's with some more seniority can then approach that physician if you're not able to do it yourself.
Yeah, that's right. It's a difficult thing to understand, but I do remember as a younger nurse that was a big deal. And there's been, I could think back to many times of my career that I should have spoken up. I hope I never stayed silent in moments where it really mattered, but I certainly stayed silent in moments where I wish I hadn't. But I mean, as I got older, it seemed like doctors got younger and my knowledge got greater. So, you just develop a level of confidence and respect from the people that you work with. So it got easier and easier. But that comes up a lot when I talk to big groups of young nurses in particular. They're like, I'm too afraid, or the consequences of this. I just try to say the consequences of that are going to be so much worse to live with than having to sort out, a doctor who yells at you or won't speak to you for 3 days or whatever happens. So anyway, thanks for that. So, and another audience for you to answer that question for is lawyers, and perhaps in this particular case, plaintiff lawyers. What would you like them to know about your role as a hospital defense lawyer and nursing negligence in general?
Well, I think it's to the people that do this work a lot. There's not much that I can tell them that they don't already know. I think what I would say is, you don't have to name every person under the sun that a healthcare organization is vicariously liable for the conduct of its employees. And so it makes everyone's lives miserable when you name a whole bunch of peripheral players that aren't necessary. So that's just one issue that I deal with fairly frequently, that is just an unnecessary delay. It's going to take longer for me to do my job. It's going to take longer for you to get your case heard if you overly complicate things. Focus on what's important. Doesn't mean that you can't question those people later if you feel it's necessary because they're employees of the organization, but focus on the key players. I think for people who don't maybe do as much of it, I would just really urge a lot of thought before going down the road of medical malpractice cases. And what I talked about earlier, focusing on just because there's an adverse outcome does not mean that there was negligence that caused that outcome. And unfortunately, for people who don't do a lot of this work, we'll get right through to questioning, and the plaintiff's lawyer will be sort of aghast that their people would defend, but the person is blind, or but the person lost their leg, or but the person, whatever it is, that doesn't mean that somebody did something wrong or that they didn't do their best. And it's just an inevitable result of their underlying condition. And so talk to experts early, preferably before you file your statement of claim, and make sure, because you're taking a big financial risk. Like it's not for the faint of heart. Plaintiffs' counsel do a great service to our society and our legal system by taking these files on contingencies where people couldn't pay for fee for service. And it's a high risk enterprise. So I just make sure that before you go down that road that there's something there, and that it's not just a result of an underlying condition.
Yeah, that's a great response.
And the only thing I would add to that is also what you touched on earlier, which is looking across the table at a nurse or a doctor at questioning. Give them the professional respect that they're entitled to. That personal attacks or overly personal style of questioning, focusing on the sort of the dramatic impact of the plaintiffs is not fair to the witnesses. The witness should be treated with respect. They went to school. They are doing their best. Even if they perhaps made a mistake, it's not because they intended to. It's because they were doing their best and they made a mistake. All of us are human. And I just think a little more from some plaintiffs' counsel, they could use a little more respect for the professionalism of the healthcare providers.
Well, that's the end of part 2 of the best of Inside Medical Malpractice. Thank you so much for listening. I hope you enjoyed this episode. I hope you learned something. I hope you heard advice that will help you now or in the future. There's so much more for all of us to learn about medical malpractice, so keep listening. Goodbye, and take good care.